You mind, come on? Good morning. Welcome.
Mr. Chief Justice, members of the court, it is truly a pleasure to come before you again. I hope I feel the same way when I sit down. I would actually like to start with one of Justice Peterson's last questions, and I hate to launch directly into areas that we didn't strictly cover in the briefs, but we developed this issue more fully in Joseph Rosenbaum's case in the Court of Appeals, and at the end of this, if you need a supplemental brief, we're happy to provide one because we have done it already. The question was, why does the Georgia Rules of Professional Conduct have some relevance to a Sixth Amendment determination? And I would propose this answer, which is drawing from case law, but is something that this court would have to find. It does have a bearing if the conflict is evaluated in a pretrial posture. The one case that does import the Georgia Rules of Professional Conduct into a joint representation situation is Registe v. State from 2010. And that was a pretrial challenge to, if I recall correctly, a refusal to take a counsel off a case when there was a joint representation. I may have that backwards. But the important thing is that it was pretrial. And the court invoked Rule 1.7 to look at what counsel's obligations to their clients were when it came to joint representation. The reason that matters, and the reason why we have to look at ethical obligations of counsel and the duty they owe to their client, is because in a pretrial context, all of these things are predictive. We're effectively looking into the fog of what might happen and trying to figure out whether there's a potential for conflict that'll mature.
And when you say predictive, do you also mean prophylactic?
Yes.
Meaning, you can make choices before a trial happens to guard against the possibility of certain rights being infringed.
Yes.
Whereas once you're there, you're there.
I fully agree with that. That's why the state had some initial concerns and did bring this up in 2017. Again, trying to look into that proverbial crystal ball about what this trial was going to look like 2 years later. The picture is entirely different post-trial. Post-trial, we have a record. We have the record of the trial showing what actually happened, showing what defenses were raised. And beyond that, we have the record of the post-conviction litigation, explaining what the conversations were, what the strategic considerations were.
I want to get to those facts, but do you have a view on whether the rules of professional conduct require things that the Sixth Amendment does not require?
I think that it is, like many things in this case, a separate but parallel consideration. The Sixth Amendment, under the case law that's been developed federally and in Georgia since the 80s, asks two questions. Was there an actual conflict, which is defined—
It asks those questions for post-trial cases.
That's exactly right, and that's the difference. That's why the Registe rule would control this, and I would be happy to talk all day about the professional rules if this were a pretrial issue. But post-trial, you have two questions. Was there an actual conflict, which is a conflict that affected the representation in a material way? And the second question is, was that effect adverse to one of the clients?
To what extent can was there an actual conflict question be informed by assessing the rules of professional conduct?
I would argue it's actually two separate things. I think that anything can inform anything else. But when you're looking at the ethical rules, what you're looking at is counsel's obligation for a client, and it actually has a completely separate remedy, right? The remedy to that is a bar complaint or professional sanctions. The Sixth Amendment, on the other hand, is a much more objective standard, and that fits a forensic analysis of a record like we have after trial. There's no prediction involved there. So instead of assessing what those duties might be and how they would affect potential conflicts that might mature into something, you're looking and saying, was there actually a conflict here? So the factors that are discussed in the professional rules are common sense things to think about when it comes to an attorney's obligations.
They're not just common sense, because if you don't follow them, you're going to get that bar complaint.
Absolutely.
So it's not just like, hey, let's pay attention,
And
it's not consequence-free.
And maybe I was too glib about that, Justice Warren. What I mean is they are the same sort of factors that you should logically consider when you're assessing whether a conflict exists, but they're not controlling. They're not an exhaustive list.
They're not controlling as to the ultimate constitutional issue.
That's correct, yes.
What's your view of what happened here as far as waiver, consent, being apprised of potential conflicts?
So I think it's important to realize that asking whether there was a valid waiver is really step two of the analysis. The court really doesn't have to get there unless they find that there is an actual conflict, and the state's position is there isn't. But let's assume there was. Then you have to assess whether that waiver is valid. I would submit that because this was a post-trial appeal, because nobody raised this issue until after everything played out and they got the result they got, that you have to approach that from a more objective way than you would if you're looking at the Rule 1.7 factors. So you have to look at whether there was a waiver and whether that waiver was valid. And of course, we do have some case law talking about what best practices might be. As we discussed, things should be put on the record. And in this case, frankly, Judge Amaro did have the conversation, but he did it through Ms. Mull, not directly with the clients.
And when we're talking waiver, because what we're talking about really is the waiver of a constitutional right, it's the due process standard for knowing and voluntary waiver rather than whatever the bar rules say about how you waive conflicts, right?
Again, that is a difference, yes. And so when you're looking at whether that waiver was valid, there's some guidance as to what the explicit things that have to be discussed are. All of those are present in this case. They're just present through a discussion with Ms. Mull. And
So, I mean, I take it that there is some significant disagreement between the sides. As clinically as you can you explain to me what you believe is in this record factually supported by evidence?
but for the waiver,
Yes.
yes.
Well, and just what they were advised of?
In general,
and-
yes.
Yeah.
And if you don't mind, I'm going to refer to some additional materials. So we know from unrebutted testimony from Ms. Mull at the motion for new trial hearing, which again was not countered in any way, that the topic of joint representation came up very early in the case. It was in the very first meetings because Jennifer and Joseph Rosenbaum always wanted to present a united front. As part of those initial discussions, the testimony was that Ms. Mull advised them to talk to independent counsel and that they at least told her they had done so. And there is nothing in the record that says they didn't do that. Then, as things progressed, the state filed its motion in 2017.
So is it your best understanding that when your opposing counsel says there's no evidence that they consulted with independent counsel, that's not necessarily inaccurate, but it's also true that there's evidence that they represented that they did?
The only evidence in the record is that they did consult with independent counsel. You have that
What's
in...
that evidence?
So you have that initial discussion that Ms. Mull discussed. You have the written waivers that were filed as exhibits, and whether those waivers complied with Rule 1.7 was a topic of discussion at the motion for new trial hearing. Nonetheless, they are there. And
So you're
part
saying
of
the
that...
waiver is the evidence that they, I think it's a little tough to say the waiver is the evidence they consulted with outside counsel. It's more like, so far all I've heard is that they've represented that they did.
And to be frank, all we have is that they represented that they had done so. I believe, and I believe the law supports, that that's all that's required. There is evidence in the record, it has been unrebutted, that counsel was brought in for this. But that's also only one of many factors that you actually have to look at if you're
To what
determining
extent
whether a
is it
waiver is valid.
relevant to consider the legal education that Ms. Rosenbaum has received?
I do think that it is...
That may be, and there may be a different answer in Joseph's case than in
Absolutely.
Jennifer's.
Well, and as much as they're conflated, we're here for Jennifer today. So to that point, she was a third-year law student at the time all of this happened. She had very high marks in law school, although don't take my word that that's in the record. But she was a third-year law student, and so she was a more legally sophisticated client. Ms. Mull's testimony is that she was constantly bringing ideas and potential issues and things to her attention. In fact, in Joseph's case, that's alleged as one of the ways that Mull was ineffective, is that she kept getting distracted so much by what Jennifer was telling her. We'll address that separately. But that was an absolute fact that you have to consider. This was a legally sophisticated client.
And perhaps, I mean, at a more general level, just participated in her own defense.
Very much so, intimately, yes. And so I think you have to factor all of that in. And there's no evidence in the record that, there's no evidence in the record to indicate that they did not go into this with their eyes wide open. Everything that you hear from Ms. Mull, everything that's represented in the written filings is that both of these parties wanted this to the exclusion of anything else. And the question that this case really seeks to answer is, where does that desire take a back seat to the Sixth Amendment?
Let me go back, and I know I've asked you this, so it's probably a rehash. Is there any dispute that Ms. Mull advised both defendants? I mean, so two questions. One is there any dispute that she had that conversation? And if there's no dispute, is then the question just how full of a conversation did she have?
The second is much closer to the question that you need to ask, because in my view, the record is very clear that she did advise them. And
And that's
that
based on her motion for new trial testimony?
it's based on her motion for new trial testimony. I believe I didn't look much at the original waiver store, I can tell you that today. I believe the original waiver said they had consulted with independent counsel. The letters that they wrote subsequently, which, and this is entirely my fault, the letters themselves are not in the record, but there's extensive discussion with them with a defense expert. Those explicitly did say, I have consulted with independent counsel. And the testimony is that Ms. Mull did not write those letters for the Rosenbaums, that each of them presented those letters to her independently after separate conversations, and in those letters, they said they had consulted with independent counsel. But again, that's only one of several factors of whether a waiver is valid. And honestly, the state's position is you don't need to reach the question of whether the waiver is valid because there was no actual conflict in this case at all, now that you look back at the actual record. And the crux of that goes to Justice Bethel's question earlier on in the argument about whether the defenses were necessarily mutually exclusive or antagonistic. They weren't. They were separate but parallel. To put it in plain English, Jennifer traveled the path of accident from the beginning to the end. Joseph traveled the path of ignorance. His entire defense was that he had no idea any of this stuff was going on either before or after the child's death. Those are not mutually exclusive, and you can assert a defense of accident without forging any kind of connection to Joseph's defense of ignorance. So you cannot say that the choices that she made with regard to Jennifer affected Joseph or vice versa because you're trying to make a connection between two separate things that never touch each other. Ignorance and accident are two totally separate types of defense. So to the extent that there are specific allegations of things that Ms. Mull could have done that would have benefited Jennifer, objecting to testimony, some of which was non-responsive testimony that might have come out at trial, the choice to not pursue a defensive alibi when there is a legitimate dispute in the evidence about what that alibi might have been, and Jennifer had already made statements saying that she was the one who performed the acts that caused the child's injury. Whether that was a valuable strategic choice, none of those things actually adversely affected Ms. Mull's representation of Jennifer. I know we dispute that, but the facts remain they didn't. If anything, they hurt both clients equally. I mean, the counselor's discussion that both of them talked about killing the child, that was both of them. It wasn't Jennifer about browbeat Joseph into agreeing to this idea. They were having a conversation. And again, that was non-responsive testimony. So we're several layers deep into some strategic thinking. So I would submit that there was no actual conflict, and even though the question of the professional rules and waiver is an interesting one, I don't know that the court actually has to reach it to affirm the convictions here.
So do you dispute the description of the seizure potentially being a result of a head trauma that potentially was outside of the timeline when she was home?
I don't dispute that there was a potential for it, which opens the avenue to making that argument, but I don't know that it's an argument that tracked much of the other evidence. There was some dispute about that evidence. There was also some dispute about whether that trauma would have been the thing that actually killed her rather than a contributing factor.
Was there any evidence in the record as to the cause of that trauma?
Well, you have Jennifer's own statement that she leaned the child up against a sink and hit her in the back as a life-saving attempt.
To the extent somebody believed that there was a seizure that was a result of trauma, was there any evidence as to what preceding the moment of this, supposed resuscitation effort, was there any evidence about what the cause of that trauma was?
To my mind, no. There was a discussion that it could have occurred up to an hour before, but that was also a very hypothetical discussion. It wasn't concrete testimony that it did occur an hour before. That was just a possibility.
No, I understand. I'm just trying to get it. When we talk about actual conflict,
yes.
I'm just, okay.
And when we talk about reasonable doubt, you don't have to have concrete, crystal clear proof that it 100% happened when she wasn't there.
Correct.
You just have to have enough to create a reasonable doubt.
That's
right?
exactly right, which makes it a tactical decision as to whether or not I'm going to deviate from the course of total innocence that it met in looking at Joseph, not Jennifer. Deviate from the course of total innocence that I've maintained up at this point, change horses in midstream 2 or 3 weeks into trial, and now assert this idea that it was Joseph and not Jennifer that might have caused that. That is strategic thinking. That is strategic considerations. And Ms. Mull testified that she didn't want to pursue that, again, because it was inconsistent with the defenses they made all the way through this case. And also, because of the disputes in the evidence, and because neither of the Rosenbaums was willing to point the finger at each other, there really wouldn't have been anything to support that aside from speculation. To the extent that we are looking back at whether there was an adverse effect on the representation, I don't believe that gets us there. So with that, again, this trial is full of several things that go down separate but parallel paths, and that also addresses the question of justification versus accident. I do want to spend just a moment on that, although I agree that the conflict is the primary thing we're talking about today. The idea that Ms. Moll was ineffective for failing to request a jury charge on justification, which is what this argument actually is, requires three conclusions from the court. First, that accident was not applicable in this situation at all, leaving justification as the sole defense that could reasonably be pursued. Second, if it was the sole defense.
Why does it have to mean accident and apply as, excuse me, as opposed to being an alternative defense?
Because in the context of ineffective assistance, the entire hook of the deficient performance argument is that a trial court is required to charge on the sole defense. And the assertion that Ms. Rosenbaum is raising is that justification was her sole defense, and thus Ms. Moll was ineffective not to request that jury instruction. Our position is it wasn't the sole defense. They could have argued it. But the very questions that the court was asking of Ms. Merchant earlier illustrate, and her responses even, illustrate that there were different options that could have been pursued as defense. This isn't a sole defense situation.
Can you briefly touch on whether justification legally could have fit the facts of this case? This version of justification.
So even, that's actually an interesting question, because the type of justification that's being argued is based on a person's need to render medical care. There's not actually any case law that I've been able to find saying that that would apply to justify the actions in this case. That it is the catch-all provision of the criminal justification statute, which then references a primarily civil statute talking about rendering medical care, I think presumably to insulate doctors and care providers from the actions they do while saving somebody's life. So I don't know that the court has to answer the question, but the state doesn't concede that that type of justification would even apply here.
But let's presume that it does.
Okay.
Often when we're presented with a claim that you should have sought justification instead of, accident or I wasn't there, we say, well, even if there was slight evidence to support it, such that the trial court would have been obligated to give it if you requested it, it clearly wasn't deficient because it's completely inconsistent with the defense you're trying to make, and it undercuts your better defense, and so, a reasonable lawyer wouldn't do that. It seems to me that framed the way that it's been framed here, it isn't inconsistent really at all with an accident theory. Like those could peacefully coexist, right?
I wouldn't say they could peacefully coexist. You can always raise, as we learned from McClure and Pennington, it's never really a good idea, but you can raise a pair of defenses that are inconsistent with each other and let a jury decide.
Sure, but my question is, why were they actually inconsistent? It may be that justification didn't add a whole lot, but it's not, I was in fear for my life and I shot this guy while simultaneously trying to argue I wasn't there. This was an accident, and I was trying to save her life. Those do seem to overlap a fair bit.
So to directly answer the question, the fact that those overlap a little bit mean the justification wasn't the sole defense. So on the question of ineffective assistance.
So let's put the sole defense thing to the side for a second. Does this type of justification require criminality?
Yes, and that's the other part of this question, of the equation here. Justification excuses criminal conduct when there's a really good reason for doing it. That, in plain English, that's what justification does.
Otherwise, criminal conduct becomes not criminal.
Exactly.
Under certain prescribed circumstances.
That's correct. Accident absolves conduct when there's no criminal intent at all. So to
get this defense, do you have to admit that you're doing something criminal?
Well, it comes
For
into...
the purposes of the defense, at
For the
least.
purposes of the defense, I would suggest yes, despite McClure and Pennington.
I think that's a very hard position to maintain post-McClure.
Which is exactly why I don't think the court actually has to get there, because they are two equally applicable defenses, which means it's not ineffective to choose one over the other. Again, separate but parallel tracks. However, I do think that at the end of the day, the choice that they made of an accident to pursue was something they were somewhat boxed into from Jennifer's initial statement to police. And so it's not unreasonable to put all of your eggs into that basket and pursue the accident theory, particularly because that's exactly what Jennifer always said is what happened. Notwithstanding the fact that there is absolutely no evidence in the record at all that the child was choking on a piece of chicken. There was nothing in the room, there was nothing in her throat, there was nothing in her stomach to support that that had any basis in fact, but that was the story they were stuck with. That's why Ms. Moll said that this was a ridiculous defense, but it was the defense she had, and it's not ineffective for her to pursue that. And
Good timing, Counsel.
thank you for your time.
Thank you both for the fine arguments. We will have you a decision as soon as possible. We will now stand adjourned until the next session of oral arguments in